Welcome back to the channel, folks. Buckle up, because today we've got a courtroom drama straight out of Texas that's packed with twists, tension, and tough consequences. The case you're about to watch involves Satara Portillo, a mother of two facing serious charges, including possession with intent to deliver methamphetamine. Now, this isn't just a simple drug possession case. The stakes here are enormous. We are talking about an 8-year deferred adjudication, multiple probation conditions, and the looming threat of life in prison if she slips up. And here's the kicker. This isn't her first time standing in front of the judge on violations. She's already been warned, given second chances, and told what's at risk. But as you'll see, the question is, will she finally take responsibility, or is she headed for disaster? Pay attention, because the judge is about to lay down a ruling that could shape her entire future. And trust me, by the end of this case, you're going to be asking yourself, was justice served, or was this defendant given more breaks than she deserved? Let's dive in.
Court is calling 2023 CR 2172 State of Texas versus Satara Portillo. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Robert Porter for.
All right, so we're here for sentencing. We've been waiting for the results of a UA, and that result hasn't come in yet. Probation, do you have any idea when that will be ready?
That was done in off-site, so if I would have thought that we would have received it by now, the results didn't go on the day. It wasn't submitted on the day that the court required, so it took a little while to get her in. So right now we're just waiting. It was submitted on the 21st, so I thought it would be in by yesterday, today, but it still says pending.
Okay.
Notice how the judge starts by digging into the basics, her kids, her job, and who she lives with. This isn't small talk. Every question is setting up a bigger picture. Is she stable? Is she providing for her kids? Does she have support at home? Courts care deeply about this, because it determines whether probation can even work. And right away, the fact that she admits to past drug use, even if it's just marijuana, is a red flag. The court wants honesty, yes, but it also raises the question, can someone who slipped before be trusted not to slip again? What do you think, viewers? Is this honesty refreshing, or just an attempt to downplay deeper issues?
All right, Ms. Portillo, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. How many children do you have?
2,
What are their ages?
6, and 14.
Are you employed?
And
What do you do?
managed properties, apartments,
Okay. How long have you been doing that?
8 years.
And does anyone live with you other than your children, or do your children live with you?
Yes, they do.
All right. Anyone else stay with you?
My aunt as well.
When is the last time you've used any type of substance
I haven't used any type of substance.
in your lifetime?
Well, no, it's been quite a while.
So my question is, when is the last time?
Probably about a year and a half ago.
And what drugs were you using a year and a half ago?
Marijuana.
That's all.
Yes.
Okay. This is what I'm going to.
Here's the big one, the judge doesn't send her to prison. Instead, he hands down deferred adjudication. Now, let's break that down. Deferred adjudication is basically a deal. If she follows the rules, completes probation, and avoids trouble, she avoids a conviction on her record. But if she violates, the court can hammer her with the full original sentence, in her case, that could be decades. Add in 200 hours of community service, parenting classes, restrictions on certain jobs, and even random field visits. This is a serious leash, folks. The judge is giving her a lifeline, but also making it crystal clear, one slip, and that lifeline turns into a noose.
Want probation? You need a pen? All right. It's going to be 8 years deferred adjudication, $2,000 fine, probated. I'm going to want her on the patch until further notice. All right. So 8 years, sorry about that. 8 years deferred adjudication, $2,000 fine probated, a patch until further notice. I'm going to want a TAP evaluation done and follow all TAP recommendations. And counsel, if TAP recommends inpatient treatment, you'll need to come back to court.
Yes, Your Honor.
There's to be 200 hours community service restitution. She's to complete parenting classes, and those hours will be waived once parenting classes are completed. And probation, you can decide which parenting classes you all think would be appropriate for her. Proof of employment. Y'all need to whisper proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Regular reporting by Zoom or in person. I'm going to want field visits one time every 3 months, random. And that's until further notice. Who is Michael Portillo? That's your
Okay.
juvenile child, right?
Yes, ma'am.
Who is Maria Avalos?
My ex-mother-in-law.
There's to be no contact.
Here's a tricky moment. The judge says no contact with her ex-mother-in-law. Seems simple, right? But then reality kicks in. She says, wait, I have to see her for child exchanges. This is the messy side of courtroom orders. Sometimes what looks clean on paper becomes a nightmare in real life. And you can see how it puts her in a tough spot. Obey the court or handle custody. Judges don't take these conflicts lightly. It's a reminder of how criminal cases can spill over into family life, affecting not just the defendant, but kids and co-parents too. Would you call this a fair restriction, or should courts make exceptions for parenting needs?
With Maria Guadalupe Aveles, I guess that's how you pronounce it, Aviles,
Fabulous.
Aveles.
Could I say something though?
Sure.
Oh. Well, because my mother-in-law, we do have a lot of contact with my daughter, so. We have to contact each other. Because I'm not supposed to have contact with her, my ex-husband.
Oh, for kid exchange?
Yeah.
I'm going to have to find somebody else.
I'll talk to her about that.
All right. Thank you. Probation, is there anything else she needs?
No, Your Honor.
Is there anything else you need from the court to be successful?
No, ma'am.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. And counsel, I believe I gave you a copy last time. Did you review that with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, from here on out,
That speech right there. Pure courtroom wisdom. The judge isn't sugarcoating anything. He flat out tells her, every choice you make now is life or prison. And here's the thing, judges don't usually waste breath unless they feel someone really needs to hear it. It's almost fatherly advice, but with a steel edge. This is the moment where the court is practically pleading with her to wake up and realize how close she is to throwing everything away. Viewers, what do you think? Will she take this to heart, or ignore it like so many defendants before her?
everything that you do in your life, there are two questions you should ask yourself before doing them. Is this something that could result in me going to prison for life? If the answer is yes, don't do it. The other question you should ask yourself, is this something that may result in me going to prison for the rest of my life? If the answer is yes, don't do it. Do you understand?
I do understand.
I take no joy or pleasure in sending the people to prison. But if it's warranted, I will. And your attorney will tell you I've sent people to prison before. So you have children,
Yes.
you need to look out for them. All right. Good luck.
Thank you.
You're welcome. All right. Court is calling 2023 CR 2172, State of Texas versus Satara Portillo, could I have the parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
The attorney of record is Joanne de Hoyos. Joseph Statesman standing in. And Ms. Portillo, will you give this court permission for me to do this in place of Ms. de Hoyos?
Yes.
All right. Ms. Portillo, did you review the document entitled Motion to Enter Adjudication of Guilt with your attorney? Did you understand it?
Yes.
Are you the same Satari B. Portillo?
And here we go, the warning signs weren't just words. Less than a year later, she's back. This time, the violation is clear, she didn't follow through on treatment. That's condition number 35, inpatient rehab. Folks, this is the cornerstone of her probation. Without treatment, the whole deal falls apart. By pleading true, she's admitting the violation, which means the judge can now impose the original sentence, anywhere from 5 years to life. This is where deferred adjudication becomes a gamble, one misstep, and the house always wins.
Who was placed on deferred adjudication in 2023, CR 2172, for the offense of possession with intent to deliver a controlled substance penalty group 1, 4 grams to 200 grams on July 27, 2023, for a period of 8 years. Is that you?
Yes, ma'am.
All right, state.
Violating condition number 35, on or about the 25th day of March, 2024, in Bexar County, Texas, the defendant, Satara P. who then and there failed to follow the TAP recommendations to include inpatient as directed by the court in violation of condition number 35.
How do you plead to that? True or not true?
True.
Your Honor, state waives all the violations.
Any objections to the state's waivers?
None.
Did you understand by pleading true to violation of condition 35, the court could find it true, grant the motion, find you guilty, sentence you up to life in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 35?
Yes.
Court will find
Notice the defense strategy here, they are scrambling to offer alternatives. Substance abuse program, aftercare, weekly drug tests, anything to keep her out of prison. But here's the reality. Defense attorneys know they are playing catch-up. They are trying to convince the court that she's finally ready to cooperate. But the judge isn't buying it. Why? Because the pattern is too clear. She already had her chance at treatment. And when someone ignores court-ordered help, it tells the judge they're not serious about change. So the question is, do you think offering stricter probation terms is enough, or should prison be the only option left?
violation of condition number 35 true. Is there a proposed agreement?
Yes, Your Honor. So alter demand for state ISF, the substance abuse program, followed by aftercare with ISP, weekly UAs with zero tolerance.
All right, so what I can tell you all, if you want to reconsider things, you can, but I'm not following that agreement.
We could step away for a moment.
We're going to go back on the record in 2023 CR 2172, State of Texas versus Satara Portillo. Could I have parties announced for the record?
Daniel Escobar for the state.
Joseph Stateson, continuing to fill in for Mr. Hoyos.
All right. The defendant had entered a plea of true to violation of condition number 35. Do you wish to continue with your plea of true in violation of condition number 35?
Yes.
All right, the court will find violation of condition number 35 true. Is there a proposed agreement?
Your Honor, if I may,
Yes.
I discussed this with the COO, Ms. Abrams, and ADA Daniel. My client is asking to be continued. We had a recommendation that was a three-way agreement. I understand the court didn't want to follow that. I had proposed something to Daniel. I'm hoping that you would consider this. But just some background a little bit first. Her prior MTR was disposed of February 27th, 2024. But she was booked February 3rd, 2024. So from February 3rd till today, according to the clerk, it's 137 days. So she's had the equivalent.
This is a classic defense move. Highlight time served. They're saying, look, she's already spent 4.5 months behind bars. Hasn't she learned her lesson? And honestly, that's not a bad argument. Jail time is tough. But here's the flip side. Those 137 days weren't a punishment the judge ordered. They were basically a byproduct of her refusing to follow inpatient rules. In other words, she dug her own hole. Judges often see that not as time served, but as time wasted. And this judge, as we'll see, isn't swayed easily.
Of a not court-ordered, but equivalent of a 4-month jail sanction, she did admit that she refused to sign conditions for inpatient. She's willing to do not just ISF, she's willing to do SAT-F. She's willing to redo all her classes. She's been in jail for quite a long time. That's her own mistake. She admits that she didn't want to sign it. Maybe she was reluctant to, but she thought that she was supposed to get out, have court, and come back and do things, and she never left the jail. And out of frustration, she didn't sign the conditions.
No, I don't think she's a good candidate for probation. She was supposed to sign the conditions, the TAP recommended inpatient treatment, and she didn't do it. So I don't think she should be continuing on probation. She was given opportunity, and counsel, as you just stated, this is not her first motion to revoke. Her previous motion to revoke was on February 27th, as you stated, and there was a violation of condition number 1. And I ordered.
The judge's frustration is boiling over here. Listen to his tone, it's not anger, it's disappointment. He points out something crucial. When a defendant listens to jailhouse chatter instead of official treatment recommendations, it's a red flag. Judges see this all the time, inmates coaching each other with bad advice. And it usually ends the same way, the defendant pays the price. The judge is making it clear, you don't get to negotiate after ignoring orders. The system gave her tools to succeed, and she threw them away.
That there be a TAP evaluation in custody to follow those recommendations. And she decided that she didn't want to follow those recommendations. I don't see how there's anything that I can do anything for her. People don't get it. You're not supposed to, when the court orders you to do something, for example, to help you by following the recommendations of TAP. TAP recommended inpatient treatment. And I know sometimes people get to talking to people at the Bexar County Jail. And when I say people at the Bexar County Jail, I mean other inmates. And they give people advice, and people want to follow the advice of an inmate, not realizing that, guess what? That person is in custody. But I made an order, and we can't do this thing where I order somebody to follow the TAP recommendations, and the TAP says inpatient, and then somebody says, I'm not signing to go to inpatient. And then what ends up happening when reality hits that your range of punishment is 5 to 99 years or life, then people come before the court and they want to say, oh, you know what? I changed my mind. Now I will do inpatient treatment. So that's where we are.
And
I don't
Your
think
Honor,
she's a good candidate.
she's also willing to take a felony conviction, change it from deferred to straight probation. She's willing to do the harsher inpatient treatment program with zero tolerance. It was a poor decision for her to not sign that. 4 months she's been in here. She's willing to sign this, willing to do this, and even add to these conditions.
I just don't think she's a good candidate. If somebody wants to argue to me why she would be a good candidate for probation when this is her second motion to revoke, and I ordered her to follow the recommendations of the TAP evaluation and she didn't want to follow them, but now she does because...
Here the defense pivots. They admit she made poor decisions, but blame it on substance abuse. And that's a fair point. Addiction does cloud judgment. But the judge cut straight to the heart of it. She wasn't just using, she was delivering. That changes everything. We are not talking about someone caught with a personal stash. We are talking about distribution, a crime that fuels addiction for others. And that makes judges far less sympathetic. So while treatment may help, the bigger question is, should society take the risk of letting her walk free again?
I don't know. I guess she thought a motion to revoke would not be filed against her.
Yeah, I didn't know that that's what would result.
Oh,
I
so
thought
these are called consequences.
Well, Your Honor, also the charge itself, people who are affected with these substances may not make the best decisions in life. To prevent her from reoffending in the future, relapsing, and she's willing to do even more intensive inpatient.
But she's charged with possession with intent to deliver, and I understand that sometimes when people have possession with intent to deliver cases, sometimes they're selling because they're also using. But the amount of methamphetamine she had was 27.980 grams. I don't think probation is appropriate for her. I'm not going to continue on probation. I'm going to revoke her and find her guilty. Does anybody wish to speak to punishment?
Defense would ask for the minimum time, Your Honor, with credit for time served.
All right, I'll send it to.
There it is, 5 years in prison. The judge gives her credit for the time she's already served, but the message is loud and clear: probation was a privilege, and she blew it. Notice how he also orders placement in the therapeutic community program, which is basically treatment inside prison. It's a way to hold her accountable while still addressing her addiction. This is the balance courts often try to strike: punishment with a sliver of rehabilitation. But make no mistake, this is a heavy consequence, and it shows just how thin the court's patience really was.
Her to 5 years in the prison. Give her credit for any time served. And I'll ask for the therapeutic community. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes.
But you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Do you understand?
Yes, please.
All right. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
And that's the end of it. After multiple chances, multiple warnings, and months in custody, Sitara Portillo is officially sentenced to 5 years in prison. What's the takeaway here? Deferred adjudication can be a lifeline, but it's also a trapdoor. Follow the rules, and you can walk away with no conviction. Break them, and the court won't hesitate to slam that door shut. This case also highlights how drug distribution charges carry far more weight than simple possession, and why judges have little tolerance for broken promises. But now I want to hear from you. Do you think 5 years was fair, or should she have been given yet another shot at treatment? Drop your thoughts in the comments. And if you found this breakdown as shocking as we did, make sure to hit that like button, share this video with a friend, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Until next time, stay tuned, and stay sharp.